Thank you, Mike. Hello, and welcome to another American Council for Capital Formation webinar. Today, I have the honor to host our esteemed panel of experts on a very timely topic, the economic impact of rising lawfare on the U.S. economy. This issue was front and center last week during the 2026 Global Infrastructure Summit. Both Secretaries Wright and Burgum mentioned increased litigation as a major roadblock for infrastructure development. And as Mike said, we just released a paper looking into 3 different avenues of litigation that is being used: NEPA, climate litigation, and legacy, as well as coastal damage litigation. The paper is available at ACCF.org. I would like to start with a very, very brief introduction of our panel. First of all, it's in alphabetical order. Mike Fragoso is the partner at Torridon Law Group. Most recently, he served as chief legal counsel to Senate Republican leader Mitch McConnell. Then I have former Congressman Garret Graves, who served Louisiana's 6th Congressional District from 2015 to 2025. Congressman Graves had a long career in public service, but I would like to highlight a specific one. He was the chair of Louisiana Coastal Protection and Restoration Authority. Next, we have Paul Hartman, Director, Midstream Policy at American Petroleum Institute. He has more than 30 years of policy experience across various sectors, ranging from energy to telecommunication. And last but not least, Alex Trembath, the Executive Director of the Breakthrough Institute. Alex works on climate policy and politics, energy technology, and other environmental issues. And I would like to take a moment for special thanks for the stellar work Alex and his team conducted on the impact of litigation, especially around NEPA. So I always believe in starting the discussion with some basics. During my research, I encountered a very interesting definition of lawfare. And I think the definition was use of law as a weapon of conflict. I will be interested to hear from each of you, given your diverse experience from policymaking to research. How would you describe lawfare, especially when used in the shaping of the U.S. economy, whether it's the energy infrastructure or manufacturing? And given that Mike has a comparative advantage, being the sole lawyer on the panel, maybe we should start with him.
Great. Thanks for having me. This is a great panel. I'm excited to do it. As to the definition of lawfare, as I understand it, it came about 25 years ago, and the idea is using sort of the law of war and other such legal mechanisms to frustrate military action by sort of an inferior power. And so it's basically a cynical manipulation of the law for non-legal policy aims. I think that's basically what it means these days, and I think it's used somewhat broadly. But it's the cynical use of law to get your policy goals done. And I think, as we're discussing here, you have a variety of environmental policy questions that are really properly in the purview of legislatures and state and federal executives, but a combination of private activists and then some local and state governments don't like how those questions are being answered, and so they go to friendly courts to coerce nationwide conformity to their preferred policies using the law.
Anyone would like to weigh in?
I'll jump in. Look, I'm a recovering politician, recovering lawmaker. And our founders came up with this incredible thought of how you're going to have these 3 branches of government in this constitutional republic. They never contemplated that one of the branches wouldn't be exercising its authority. So how many of you have heard about activist judges and legislating from the bench? How many of you have heard about, and I want to be clear, under both Republican and Democrat administrations, executive overreach? You've all heard it. And what's happened is as Congress has become more dysfunctional, its inability to be agile and prescribe solutions, you've had the two other branches of government that have begun encroaching. And so if you have an objective, if you have an objective to stop a project, if you have an objective to get rich quick, you find the softest point. And at this point, the courts are the softest point because in many cases, Congress has not been specific or prescriptive enough for people like Michael to be able to get a clear understanding of exactly what the intent was in the law. And so you've found these activists that have just gone and they've gone judicial shopping, as Michael indicated, finding the court that's going to be most sympathetic. And it's incredible because it's having a profound impact on outcomes in our country by people that were not elected, people that were appointed for these lifetime appointments. And look, I'm not knocking the judiciary. What I'm doing is I'm saying that it's problematic that Congress has become dysfunctional and that the softest point, the weakest link in the overall chain is going through the judiciary system. And lastly, I made a point about if your goal is to get rich quick. Like I want to tell you a scenario that happened at home. From South Louisiana in New Orleans. There are currently 63 indictments for a group of people that have staged 150 collisions, wrecks, traffic accidents, or intentional. There was actually a witness that was killed that was cooperating with the FBI. This group found a weak link, and they now have been able to get millions and millions of dollars in judgments using this weak link in the system to enrich themselves. This is a massive problem, and we've got to fix it.
I agree with what Michael and Garret have said, and I should say that as a longtime fan of Congressman Graves' work in Congress, I would say that he was one of the legislators who was actually trying to make Congress productive, within this kind of milieu in which the legislature is being crowded out by the judiciary and the executive, or one might say the legislature sort of abdicating its responsibility as the sort of democratic representative of our democratic republic. The aspect I would add to the conversation about lawfare is the emergence over the last half century or so of what's called the public interest movement in the United States, which comes out of the ideas and kind of work and institution building of figures like Ralph Nader and in the environmentalist movement and groups like the Natural Resources Defense Council and the Environmental Defense Fund. Many environmental and sort of public interest groups of which still do good work in consumer advocacy and things like this, but groups that figured out, institutions that figured out how to kind of use the law, use the judiciary, use litigation as a way to sort of represent special interests. And I say that as neutrally as possible. We figured out through kind of sort of public interest and environmental law over the last 50 years or so, how to kind of pursue policy and sort of ideological goals through other means than through sort of legislative policymaking. That includes the kind of litigation under procedural laws like the National Environmental Policy Act, which we'll talk about, and so this kind of special interest movement, and I say that as a representative of a nonprofit. I'm part of the system in a way. The special interest movement has really figured out how to use sort of lawsuits, litigation, what I think we rightly call lawfare, as a way to kind of pursue environmental goals like sort of like shutting down fossil fuels, or sort of community goals like like opposing a certain kind of infrastructure or landscape management project. I think there are more and less legitimate ways to go about doing that, and I don't want to say that the public and environmental causes should have no voice outside of the four walls of Congress. But I do think that we have sort of defaulted towards policy pursuit by other means than sort of legislative, sort of democratically accountable institutions is the kind of feature that I would emphasize when we're talking about lawfare.
I think just to add to that, I would highlight that litigation has always played an important role in enforcing our environmental laws and ensuring accountability. When you look at the development and the planning for large-scale infrastructure projects over the last couple decades, there are a myriad of federal and state authorizations and permits and certifications that are necessary to move that project from concept to in service. And what we have seen is that expansive permitting process for these various types of large-scale infrastructure provide ample opportunity at every stage of the process for opponents of these projects to intervene through lawsuits and to use the court system to advance both their policy preferred outcomes and even help try to shape the economic policies around infrastructure development. So this has become a tool that creates multiple weak links in the process and really has stymied investment in large-scale infrastructure projects. If you look at things from either our pipeline system or our grid or the support infrastructure, roads and bridges for increased manufacturing, these have all been targeted by this process where you have multiple entryways to challenge permits and siting throughout the process.
So to sum it up, do you think, is it fair to say that it's basically replacing policymaking in the US? And I don't want to just simplify for US because I think it was the UN's climate litigation report that was pointing to increased litigation everywhere in the world, even though majority of it's happening in the United States.
Yeah, at least when it comes to sort of environment and climate, and what everyone thinks about putting a price on carbon or a carbon tax or things like that, at least for now, we see sort of the environmental movement seems to have given up on that, and seems to have given up on the expectation that we would actually pass sort of legislative policies to manage the climate problem. And now we see sort of going alternate routes. One is the sort of classic sort of throwing their bodies on the gears of the machine and things like civil society protests of charismatic pipeline projects. So that's a little bit outside of the sample for this conversation. But another one is this conversation is trying to sort of put limits on emissions, on fossil fuel infrastructure through litigation. And we'll talk, I think, a lot about things like NEPA. But there's a whole new kind of host of a whole new sort of style of litigation that has sort of cropped up in the last decade or so around liability for damages from climate change, and sort of trying to sort of put limits on fossil fuel emissions through the judiciary by suing the Department of Energy for not stopping fossil fuels or not stopping emissions, or suing the state or suing big emitters directly in district court for emitting in the first place. And these are lawsuits that are not filed under any particular law. There is no sort of policy creating a liability for global climate damages at the moment, but there you have over 1,000 lawsuits in the United States actually alleging that such liability does exist. So I do think that for now, a good portion of at least the kind of environmental movement has turned its attention away from trying to sort of pass legislatively legitimate sort of policy and climate policy, sort of emissions constraints, and are pursuing those constraints through the judiciary.
Yeah, in short, is lawfare replacing policymaking? The answer is yes. In many cases, it is. We're using, in some cases, laws to govern the internet that were written 100 years ago. I don't need to remind you, the internet didn't exist then. We're using environmental laws that were written 50 years ago that don't understand, didn't anticipate newer technology. And even the Supreme Court, with the throwing out the Chevron deference last year, that was a call for Congress to be more involved, a call for Congress to be more prescriptive. And because of the inability of Congress to act and actually engage and update laws and stop this ridiculousness with things like wetlands litigation, regulations going here, litigation coming out every 5 or 10 years, yanking it back, you have uncertainty, unpredictability. And there's no question that it's crystal clear. The answer to your question is yes. Lawfare is replacing policymaking.
And just to follow up on the point on, Congress's role to give directives that the agencies are to implement. We're seeing more frequently litigation proofing of reviews and environmental documents at the agency level, trying to anticipate all the venues and ways that activists or concerned citizens could bring suit against the agency. And they are going beyond the scope of what their agency is to consider. They're going beyond the intention of the statute as it was enacted. And we're seeing this continual evolution on a permit by permit basis of what it takes to move a project forward. The other thing that folks often don't consider is we talk a lot about the cost of investment to the project sponsors. When you have these projects litigated at multiple stages at either the federal or state level, that is a significant cost to taxpayers. There is a significant cost for defending these determinations. And when you have a track record, and I'm sure Alex will get into this a little bit later, when you have a track record where the agencies prevail more often than not, this has a cost both to the projects, to consumers, as well as to taxpayers.
Well, and it has a cost to, it has an opportunity cost. The way that NEPA, for instance, was set up was as a check against the kind of unmitigated industrial and ecological and sort of public health, public impact horror of factories, of roads, of pipelines and things like that, as the congressman notes 50 years ago. I don't want to say that the kinds of big infrastructure projects that are sort of being developed today have no local environmental or public health impacts, but they just are less polluting and less destructive for both kind of policy and sort of technological reasons than the coal plants and the paper mills and the oil refineries that were being built 50 years ago. We have new pollution controls. We're building a lot more infrastructure that emits really no pollution when you start to talk about like renewables and nuclear, and even natural gas plants produce very little local pollution. Same with pipelines actually. And all of these projects, are not without their local impacts, but in addition to the direct economic cost to taxpayers you're talking about, Paul, from this litigation and from sort of endless environmental review and the sort of procedural doom loop that these projects get caught in, these projects have public benefit. We're trying to build energy infrastructure in a nation that faces an energy crunch that gets worse by the day. If you read about what's happening in the Middle East, right? We're trying to build transit infrastructure in cities that are increasingly choked by traffic, which also creates more pollution, right? So there is actually not just a kind of taxpayer, but a really sort of broad sort of public cost to lawfare.
Well, Alex is moving quicker than me. Let's divide the remaining part of the conversation into three main groups so that we could have a general theme. I think the first part is the economic questions associated with the litigation. The second one is the legal questions and environmental questions. And if we start with the economic questions, obviously people generally associate these lawfare mainly with the fossil fuel industry, but Alex's work and other work also shows that it's way larger than that. Financial sector is getting hooked into this. Telecom gets hooked in. There's a lot of parts of the economy is impacted. And Alex, your research highlighted some very interesting facts in terms of which industries have been targeted, the impacts on project timelines, the results. Can you highlight some of the findings, especially how NEPA has stood in the way of permitting for clean energy projects?
Absolutely, Pinar, and I'll highlight just a few kind of surface level findings of our research. Listeners can go to navigatingnepa.org if they really want to dig into our database. We documented over 1,400 lawsuits, against federal agencies who had produced environmental assessments, environmental impact statements over roughly the last decade or so, to try and figure out like what actually does get sued, what are the results of these lawsuits, how long do they take. And so for instance, like we were talking about, like the panel was talking about a moment ago, I think one common assumption is that NEPA in particular, which is the law that our data set examines, that NEPA in particular is a check against the fossil fuel industry, for instance, and that, sort of like natural gas plants or oil pipelines need to go through NEPA in order to actually get a permit and get constructed, and that this is a sort of form of environmental protection against climate change and the fossil fuel industry. What our research found was that sort of carbon and non-carbon energy projects get litigated, get sued at roughly equal rates. So if your interest is a kind of all of the above energy deployment, then NEPA's equal opportunity offender. If you're trying to get both sort of gas pipelines and plants and also solar farms and wind farms and nuclear plants built, NEPA is a check on all of the above. If you're more of a sort of everything but fossil kind of advocate, if you're a clean energy advocate, if you're a climate advocate who does in fact want to see the fossil fuel industry phased down, quicker than I expect it to be, frankly, then NEPA is still a problem. NEPA is a huge obstacle to the build out of power lines and the solar and wind farms themselves. Another even sort of less understood feature of NEPA litigation, though, is that the single biggest target for NEPA litigation is forest management projects. So these are environmental assessments and impact statements and permits issued largely by the U.S. Forest Service to work with contractors to go in and clear forests through mechanical thinning and controlled burns to try and prevent the kind of out of control wildfire problem that has become so pronounced in especially the Western United States in the last decade or so. I'm joining the panel today from Oakland, California, and we've had many years over the last decade or so where we're advised not to go outside at all for days or weeks on end. And we're hundreds of miles from where the fires are, and that's because our forests are overgrown after a century of neglect, and the U.S. Forest Service is trying to do something about that by doing sort of risk-targeted land management of the areas of the forest that are most at risk from sort of out of control wildfire. And a literal handful of groups is responsible for the majority of the litigation that stalls these forest management projects for oftentimes years on end. And in our report we identify several major forest management projects that were delayed so long, like controlled burns of forest management projects to try and mitigate the risk. The projects that were delayed so long that the entire forest burned down while they were waiting for the litigation to be resolved. And that brings me to sort of my final sort of high level observation, which is that most of these lawsuits are brought by a small group of local and especially national environmental nonprofits. Most of the litigation is brought by environmental nonprofits, particularly again on the forest and land management side, to try and reverse agencies' issuance of permits for transmission lines, for forest management projects, for clean energy projects. And as I think Paul referenced earlier, most of these lawsuits, 75% or so of these lawsuits, according to our findings, fail in court. The agencies overwhelmingly prevail, and even the suits that succeed, that result in a revision to the permit or to the EA or to the EIS, are not found to sort of result in big environmental remediation of the projects. So these are, in our sample, it sure looks like sort of environmentalists, special interest are suing the federal government, delaying the actual development of not just dirty but clean energy projects, as well as good forest management, for an average of 2 years, and across the whole sample, an average of 3 years in the case of forest management projects, and up to 6 or 7 years. And that's after the maybe many years that it took to write the the NEPA
Yes.
documents in the first place. So we're talking about, in many cases, the better part of a decade, developers spent in this litigation doom loop for litigation that overwhelmingly fails in court, and that even when it succeeds, doesn't produce sort of demonstrable environmental improvement in the projects themselves.
Thank you for that. Also, I mean, to follow this economic arguments, we are in the midst of affordability crisis. I mean, the word is appearing everywhere, right? The job market is softening. I don't need to mention Iran, energy crisis. And at the same time, we have this exponential increase in energy demand. We have a limited amount of budget, and I believe the litigation is impacting the budgets of the projects as we delay their finalizing. I think one example I have seen was New England Clean Energy Connect transmission project from Quebec to Massachusetts. Because of the delay, the project cost increased by 500 million, which the money could have been used for something else. So how do you see the lawfare contributing to affordability crisis? And if you don't mind, let's start with maybe Paul.
Sure. So if you think of an energy project, it requires significant capital, it requires long-term planning horizons, and it requires a certain level of certainty, both on durability of the permits, but certainty that you are going to be able to meet your targets to get into service. You look at regions across the country, and we've got, when it comes to energy costs, we've got multiple different countries. We have different energy costs in different regions, and that is based primarily on the ability to get the energy from its production area to the demand area. So if you take a look at something like New England and their natural gas costs, they are sitting right next to one of the most prolific natural gas basins in the world, the Marcellus Shale. Natural gas costs in Pennsylvania, in Ohio, and in the Midwest are significantly reduced compared to the Northeast. And why is that? It is because we have had this litigation and challenges against building out pipeline infrastructure that would deliver neighboring Marcellus gas to New England and provide them with the economic relief that they need. If you ask any CEO of any manufacturing firm or any other group that wants to build something in the United States, one of their top issues has always been, and the congressman, I'm sure, can cite group after group after group that's been in his office, energy costs determine where people cite their investments. And capital always flows to the areas of least resistance. So where we can build out the capacity, where we can move it from production area, whether it be fossil or renewable, to the centers of demand within the country, we are going to take some of that economic pressure off those regions and allow them to have the economic growth that every community wants to see move forward.
Congressman Graves, would you like to weigh in?
Sure, I'll jump in. Look, Paul highlighted something that's really important. So look, if you have a set of rules that are clear, if you have certainty, then it makes your project schedule, it makes your investments, your capital expenditures much more clear. In a previous life, I was responsible for tens of billions of dollars in infrastructure. And of course, that included us having to predict how long it was going to take us to make it through the regulatory process and when we were actually going to be able to put shovels in the ground and turn dirt. And every time we were faced with a situation where you had regulatory uncertainty, or if a lawsuit was brought up, it would increase your costs. But importantly, it also prevents the positive outcome of your project from being realized by the public. Now, when I made reference to tens of billions of dollars in infrastructure, I was building resilience projects after Hurricane Katrina. I wasn't doing anything that was harmful to the public. To the contrary, we're trying to protect communities that have been devastated, and we were trying to restore coastal wetlands for their ecological productivity. I think those are laudable goals and things that I will tell you, nearly 100% of the public in South Louisiana support it. But what happened is, as projects were dragged out through different regulatory delays, through lawsuits and others, we had projects that would literally increase exponentially in cost. And so one of the things about the United States that has attracted capital was the predictability or the certainty. We're not some third world country that's going to come in and take over your company, take over your project. But I think increasingly the certainty or predictability in the United States is diminishing. That has an impact on investment. It makes it more expensive to do business in the United States, and in some cases really dissuades or repels capital investment, which means jobs, which means affordability, and going back to my point earlier, which means delaying or preventing those positive public outcomes that these projects are intended to achieve.
Congressman, am I correct in terms of saying that certain states really get hit hard with these litigation, especially Louisiana? Because I know Pelican Institute did some number crunching, and they compared how, for example, the oil and gas employment in the state decreased compared to the national average, and they found that it was much larger since those lawsuits started. I think the legacy ones somewhere around 2003 and coastal damage is somewhere around 2013. And I know once you mentioned to me how the jobs were leaking out of the state to other states.
Louisiana historically has not been a very litigious state, and I think that it caused historically capital to be invested in our state. You had, again, better certainty or predictability. But what's happened in more recent years is you have had more litigation pop up. In fact, Louisiana is the only state in the South that actually lost population during COVID. And unfortunately, that loss in population has continued. Here we are facing an affordability crisis. And as you noted, we're facing a situation where there's increased demand for energy. Louisiana, one of the most energy-rich states in the country, has actually, we've had decreased production in our coastal area for energy. And this is resulting from the litigation, from the lawsuits that are occurring. And I'll tell you something else that you didn't ask, but very personal to me, is that Louisiana's coast is different, and that 82% of our coastal area is actually owned by private individuals and private companies. Most states have public coastal lands and beaches. 82% of coastal Louisiana is privately held. Whenever we're out there trying to build projects for resilience, whether it is restoring coastal wetlands or it is building things like levee protection, the involvement and the cooperation by the local landowners is critical. Because the majority of that land is owned by energy companies, they're now saying, look, we don't want to have anything to do with you because we're concerned we're going to get sued for being involved in these projects that are designed to do only public good. So it really, the impacts aren't just limited to employment, to economic development, to investment, but it's actually having repercussions on the resiliency of communities, which is just an awful, awful outcome.
Let me pose my questions for a few minutes because I got a good question from Rick Wilber from Inside EPA. His question is, and I agree with him because right before the presidential election, we did another panel with the CEOs of various energy resources, and they were all complaining about NEPA and permitting reform and all of these things. So he's asking, given the congressional dysfunction being discussed by panelists, can someone talk about struggles to pass permitting legislation? Would SPEED Act fix some of that report highlights?
I think
I don't know what to add to what Congressman Graves said at the opening of this conversation. Our legislature has largely kind of abdicated its responsibility at sort of passing, not just passing policy, but passing clear policy that kind of creates the clear guidelines and certainty that the Congressman was talking about in his last response. And the now like multi-year, sort of unconsummated struggle to pass, sort of meaningful federal permitting legislation is just one instantiation of that abdication. There have been encouraging signs over the last few years to sort of deal with the the nation's sort of energy gridlock, sort of energy supply crunch, right? Energy affordability crisis. We passed the Fiscal Responsibility Act in 2023, which made some changes to NEPA, which were sort of largely superficial, especially in retrospect. We almost passed the energy permitting the permitting package at the end of the Biden administration that failed in the lame duck. And now, as questioner Rick Weber mentions, we have the SPEED Act that passed the House last fall, and Senators Capito and Whitehouse and Heinrich tell us that they are hard at work drafting companion permitting legislation in the Senate. And so that's all good. And I remain hopeful, if not overflowing with optimism, that will pass permitting legislation in this Congress. And so that's the final point that I would make. This should not be hard. The policy making might be hard, and crafting the right kind of reforms to NEPA is in fact hard. These are not just, or I should say, it's not exactly a complicated law. NEPA is 7 pages long, and it basically just says that federal agencies should consider the environmental impact of major infrastructure projects. And all of the lawfare that has become associated with it is the result of jurisprudence and sort of public interest movement norms that have come to define how the law actually works in the real world. But all of that, how NEPA actually works in the world, is complicated, and how to reform it is complicated, and requires that our Congress does the work and actually passes good, meaningful, well-founded legislation. But it shouldn't be hard to pursue that in the first place. And we're now multiple years into a kind of dithering on permitting politics, where we say, oh, like we might pass the bill if we can all get along, and if the Trump administration stops doing its shenanigans, and if we can get the utilities on board. Energy was always fundamental to not just industry and not just commerce, but to sort of every aspect of American life. Energy costs are going up in every sector of the economy. Our infrastructure is decaying. We have a lawfare problem. These are increasingly recognized. There's bipartisan recognition of these problems, and yet it's still far from obvious that will pass meaningful or any permitting legislation in this Congress. And I apologize to the listeners that the main thing that I can express about this at this point is anger.
And I think we've seen over the last year kind of a convergence of issues that create an opportunity that we haven't had in the previous years of discussion on permitting reform. We've seen the emergence of AI and compute infrastructure needs that are moving at a pace faster than any other sector of the economy historically has. That's creating increased demand, and you're seeing that impacted in regional utility prices, electricity prices. I think that there is also a convergence around on what the key issues finally are, whether it be statutory reforms to NEPA or the Clean Water Act. But I don't want to lose sight, too, that judicial reform in that package is going to be critically important, both in terms of taking a look at the standing for who can bring suits, making sure that the courts are not vacating permits, but remanding them back to the agencies so they can remedy the deficiencies, providing clear guidance to the agencies as to how quickly they should remedy those deficiencies, and then making sure that there's not a second bite at the apple, that when additional litigation is brought, and it will be brought, that it is limited to those changes that were made after the initial permit was remanded back. I think if we get right sizing of the scope, both under NEPA and the Clean Water Act, and limit the areas that folks can look at because there's clear guidance from what the agencies should consider, and then we have this tailored approach on the litigation reform, I think we're going to build a lot of efficiencies back into the agencies. I think we're going to reduce costs for projects, and we're going to reduce timelines, which will be good for every builder of anything in this country.
So since we are getting short on time, I would like to touch on the legal issues, and I'll turn it over to Mike. But there were significant developments. Supreme Court just took the case for Exxon versus Suncor. So the question is, are the state courts appropriate venue to address interstate and global environmental issues? how will Supreme Court's final decision will impact the trajectory of the climate change litigation?
Yeah, it could wind up having a pretty big impact on that, and I sure hope that it does. These cases are popping up all over the country. So the Suncor case is out of Boulder, Colorado, but there's cases in New York, in Michigan, Hawaii, Vermont, Portland, New Jersey, just go down the list, DC. Even Charleston, South Carolina had a climate lawfare case where they were trying to sue the oil and gas companies for the supposed effects of climate change. All of these cases wind up being brought in state courts because they're a more favorable venue. And I think that they're all inappropriate because what you have is state and local governments trying to hold national and international companies accountable for actions that took place outside of the state. And they've got various theories of liability for how they do it. Some of these states pass their own, they call them climate superfund statutes, which is its own sort of cause of action against these companies. Other ones just use traditional state tort law to go after these companies. And another one, which is becoming more and more of a problem, is they use consumer protection law to go after oil and gas companies, basically saying that they've been misleading people about the effects of climate change. Those are a little less bad than the other ones in some ways because they're statutory damages and you don't have the potential trillions of dollars in damages that their experts say that the oil and gas companies owe in some of these tort cases. But essentially, they're going after oil and gas companies and their trade associations for First Amendment activity, where they're trying to persuade people about political issues. And they're saying, no, you're lying about the effects of oil and gas, so you're liable under consumer protection laws. What's important about the Supreme Court case is in the past, there's been some success in arguing that the Clean Air Act preempts some of these state lawsuits. But that's relies on the particulars of the Clean Air Act and whether you're going to get some sort of statutory preemption there. At the Supreme Court case that's been taken now, Suncor, it's about whether the Constitution itself precludes these kinds of lawsuits. And it's a sort of novel theory that the court's going to be looking at, novel theory I think is right, that it's not, looking at what's known as the Dormant Commerce Clause, which is kind of this disfavored theory that because Congress can regulate commerce, that means the states can't regulate commerce between the states. Justice Thomas is famous for thinking that's just kind of nonsense. There's no dormant commerce clause in the Constitution. But what you do have is a Constitution that sets up a federal government above the states and then the states next to each other. And that would seem to imply that one state can't regulate the laws of another state. And it's kind of why we have the Constitution to begin with. So that's what they should be looking at. That's what the Solicitor General told them to look at. Their argument in their amicus brief was, saying that implicit in the Constitution's structure is the limitation on the principle that state sovereign authority is bounded by the state's borders. And making that argument and getting the court to hear that argument and accept that argument, I think will be very powerful in terms of preventing these states from trying to bring lawsuits that essentially regulate activities in the other states. And the effects of these lawsuits, again, really just can't be overstated. You have damages experts literally saying that the damages are in the trillions because any wildfire out west or whatever, find your natural disaster and they find some way to blame it on specific oil and gas companies. And so the clear goal is to bankrupt these companies and to put them into some kind of receivership and fundamentally change how we handle energy in the United States.
Michael, you're of course right that there's like thousands of these lawsuits, right? And they use various different sort of legal justifications and mechanisms and venues to sort of pursue climate liability cases. I think they've been sort of most successful in Montana, for instance, because Montana has a provision in its state constitution, a right to a healthy environment. That judges have interpreted sort of generously towards the plaintiffs in some of these in these climate liability cases. But just as a kind of reductio ad absurdum for the damages that are being pursued here that you're talking about, Michael, one of the federal cases, Genesis versus Lopez, that was brought by Our Children's Trust, which is an environmental group during the Biden administration. Our Children's Trust sued the EPA under the Biden administration, the Department of Energy, on the grounds that the Earth's atmosphere exceeding 350 parts per million is unconstitutional because it violates the claimed constitutional right to a livable climate under our constitutional right to life, liberty, and the pursuit of happiness. For those listeners who don't know, atmospheric concentrations of carbon exceeded 350 parts per million like 60 years ago. So the claim of this particular lawsuit, but I also think the sort of general view of this style of litigation is that all energy policy in the United States should be invalidated because it has failed to sort of achieve the atmospheric climate targets that are claimed by the plaintiffs, which gets back to the conversation we were having earlier about sort of policy pursued by other means. We don't have a carbon tax. We don't have a sort of congressionally passed limits on climate change, and these lawsuits, whether at the federal or the state level, are trying to enforce these climate targets through the courts, and in my view, amount to a kind of end run around sort of legislative legitimate democracy.
One of the lawyers in the Suncor case did a Federalist Society panel a couple months ago where he said, "This is a climate tax. It's a carbon tax that we are imposing through the litigation." And they tried to pass it in Congress, it didn't work. And so to the sort of theme everyone's been touching on, Congress hasn't done these things, but now you have activist public interest legal groups, contingency fee lawyers, and state and local governments just doing it themselves.
Well, on a carbon
An
tax,
important point
you're talking about. Oh, sorry, excuse me.
I was going to say just an important point to make here. If you truly care about the global environment, if you care about the climate, one of the most effective tools to addressing that is by actually having more manufacturing, more production, more agriculture in the United States, because we have the most efficient economy in the world. And the lawsuits that Michael's discussing is actually dissuading that, therefore having an adverse impact on this larger goal.
But Congressman Graves, to move on that issue, actually, one thing that really bugs me about whether it's legislation or litigation is the retroactive nature of these lawfare, right? Because we are targeting activities that were legal when they were accomplished. And I think this is very relevant because if I read it correctly, President Trump now invoking the Defense Production Act to restart oil production in California. Who will take on, who will produce? Mike, let's start with you about this retroactive nature of these litigation, how it's impacting everything.
Look, I mean, the retroactive nature is like having a time machine, right? I mean, it's like, if I knew that this lottery ticket wasn't going to win, I wouldn't buy it. If I knew I was going to get in a car crash, I wouldn't have gone. I mean, and so look, you have to operate with the best information that you have at the time. And you want to talk about chilling investment and preventing job creation and economic activity. It's those sorts of unfair, unrealistic conditions that chills investment. And so look, I want to be clear. I want to protect the environment. I want it to be healthy and productive for future generations, for our kids and hopefully grandkids. I hope you're listening, kids. And so I think that's critically important. But you can't sit here and begin applying science from 50 years from now, from the future to today. You've got to operate and make decisions on the best information that you have available. And so attempting to come in and retroactively apply science, especially in cases where someone may have bought a company and then they bought them, and all of a sudden generations before you're subject to liability that you had no idea existed. This is crazy. And once again, these are things that chill investment. It prevents economic opportunity. It prevents upward mobility for citizens. So the consequences are profound. In the crazy scenario that I laid out earlier with these staged collisions in Louisiana, it was calculated this is costing a Louisiana family $600 per year more in insurance premiums. So there are profound impacts on individuals, and that's where we need to stay focused on outcomes.
Mike, what do you think?
No, I think that's absolutely right. And the retroactivity problem is a big problem. It's a particularly big problem down in Louisiana. That was another Supreme Court case that they heard this year. The Plaquemines Parish case about Louisiana land loss litigation. And so those cases, there's about 40 some odd of these cases alleging that the oil and gas companies caused land loss on the Louisiana coast. The trouble is, it's all based on a law that Louisiana passed in 1980. A lot of the activities that they're being accused of having participated in that caused the land loss date back to World War II. The case at the Supreme Court had to do with exploring for oil to create aviation petroleum, avgas for the war effort in World War II at the direction of the federal government. So these companies are being held liable for activities that predate the enactment of the law by almost 40 years. Not only that, but the permitting regime that the law put in place after 1980, if these companies had gone to the Louisiana Department of Natural Resources or whatever and asked for a permit to allow them to do this sort of thing, they would have said, no, we're not, that's not what this law requires. So they're being held liable for activity that predates the law and that the law would not have allowed them to cure, because the law, as interpreted up until about 10 years ago, was that it didn't require any of this. So it's Congressman Graves talked about, it's like having a time machine. It's Justice Scalia used to talk about how the Emperor Nero would put laws in very small print up really high so nobody could know if they violated them or not. It's kind of like that. And that's what's been happening in Louisiana. It's just been awful for their oil and gas industry. I think you mentioned the Pelican Institute. They did a report on this, and not only just Louisiana versus the country nationwide, but Louisiana compared to Texas. Since they've been doing these lawsuits, I think it's Louisiana crude production has plunged by over 50%, whereas Texas, right next door, over the same time period, has more than doubled. And similar oil, both, good conservative states. What's the difference? Texas has really good tort laws, and Louisiana's subjecting these companies to retroactive liability.
Well, it's not just retroactive liability for activities in the far past of these companies' histories. It's that the sort of climate damages being identified in these lawsuits are the result not of a company's sort of cumulative emissions over 50, 100, 150 years, but of 250 years of emissions of the entire world. So it's important to be clear that climate change is real and that climate impacts are real. And the climate change, for instance, does make the temperatures in the West hotter and the forest drier and the fires worse. They don't cause the fire. Climate change doesn't cause the fires, and it's complicated. But it's important to understand that people are right to be concerned about wildfires and sort of coastal flooding and things like that. But these climate, not only these climate impacts sort of routinely kind of exaggerated in these lawsuits outside of the mainstream science. But the literal liability that is being alleged is on particular companies. The climate superfund bill that they tried and I think have largely failed to pass in California would target emitters who emit over a billion tons of greenhouse gas emissions annually in the state, and charge them liability for climate damages like the Palisades fire that occurred last year. But the emissions that are identified in these lawsuits are like a fraction of a percentage point of the cumulative emissions that cause those identified climate damages in the first place. So it's just not like we can't actually be using torts or liability law that exist to sort of tie one company or one factory or one nation or one government's energy policy to these targets. Climate change is a much bigger, more complicated global problem that is sort of disintermediated by infrastructure and economic growth and all sorts of other things. And so I would just circle back to I think all of our argument that we're sort of trying to pursue a kind of anti-fossil fuel agenda, a kind of climate policy agenda outside of legislative pathways. Mike mentioned a carbon tax, which we have failed to pass in the United States earlier. A carbon tax is one thing. If you put $50 a ton on a carbon tax, that's like 40 or 50 cents on a gallon of gasoline. I don't mean to diminish the economic impact of that. There's a reason we haven't passed a carbon tax in the United States. It would be economically painful for most Americans. But when you're talking about these lawsuits, you're talking about trying to immediately decimate really all energy infrastructure in the United States, which is another reason that I think the kind of public interest environmental movement has moved away from legislative pathways towards what I think are ultimately going to be less successful, but are sort of much more severe attempts to sort of restrict energy investment and energy production in the United States.
I'm regretting that I didn't ask more time from you guys to discuss this issue. It seems like it's very interesting and we have a lot to say. Briefly, Congressman Graves, one issue that I have encountered when I was doing this, I was writing this paper, people were trying, they were trying, or they were discussing the effectiveness of these litigation in terms of environmental, addressing the environmental consequences. And you have worked as the chair of Louisiana Coastal Protection and Restoration Authority. That's the reason I picked it. What do you think in terms of, we're talking about hefty amount of money changing hands. How effective they are in terms of addressing some of these environmental consequences that the litigation is talking about?
Coastal Louisiana is an incredibly complex area, one of the most productive ecosystems on the North American continent, the biggest maritime and port system in the Western Hemisphere, and one of the largest port systems in the world. In South Louisiana, energy production doesn't have the beaches like many other coastal states have. We're primarily coastal wetlands, so look really complex. But the bottom line is that you cannot solve Louisiana's coastal problem through litigation like this. The solution is reconnecting the river. And without getting into all the weeds, the bottom line is that the canals that were built for oil and gas production, as Michael noted, at the demand of the federal government, those would actually serve as conduits to restore or convey sediment and fresh water, which would benefit our coast had the federal government, the U.S. Army Corps of Engineers, not installed levees on our lower river system. Bottom line is that you have chilled the 82% of private land in Louisiana. You've chilled those landowners, prevented them from participating in these projects for resilience, for restoration. And at the same time, and we can't say this enough, this is about people. Michael talked about the reduction in oil and gas production in Louisiana. Lower supply means higher cost. And so this is having an impact. As I said earlier, we're the only state in the South that has lost population during COVID and continuing to do so. This is having a profound impact on our economy, on our state, on our coast, and on our future. And so this is not benefiting the environment. Last thing I'll say, I was privy to some of the earlier discussions on settlements for these lawsuits, and folks were talking about obscene amounts of money going to the trial lawyers and going for non-restorative activities rather than actually what I thought was supposed to be a pure intent of actually restoring the coast or the environment. So really just this is not the approach, and I've spent most of my life trying to restore and protect coastal Louisiana. This is not the approach. It's not the solution, and I think it's actually contrary to the objectives or the real best interest of folks in South Louisiana.
To conclude our discussion, what is the solution? I mean, I know there is a lot of chatter around NEPA and reforming NEPA and all of those things, but what do we do about the climate litigation, the legacy litigation, coastal damage lawsuits? How do we bring more clarity and certainty into this economy now if you want to really build the energy infrastructure and manufacturing as the President Trump envisions?
Look, I was at a COP meeting, convention of parties overseas. I had John Kerry and Brian Deese, top Biden administration officials, walk up to me in the room. First thing they said, we need permitting reform. It's like, gosh, that's really weird because you look like John Kerry and you look like Brian Deese. Like, I never thought, so look, this is something that should be bipartisan. I think number one is you've got to correct the standing issue that was discussed earlier, meaning not anyone can just come in and file a lawsuit. Number two is you've got to put a cap on the statute of limitations, the amount of time that it can take that you have to file a lawsuit after a final permit decision has been made. I think those things are absolutely critical. It's all about providing certainty and predictability. Look, you can think I'm a conspiracy theorist. Hillary Clinton said that the Russians were funding environmental groups to prevent energy production in the United States. That we're right now in an AI war with China. Do you think that they would be pursuing these weakest links, these ways to slow us down and delay us? I sure do. I absolutely believe they're using every tool that's available. So what the United States needs to do, taking legislation like Congressman Westerman and Congressman Golden have introduced the SPEED Act and passed through the House, getting that advanced, having the Senate provide their companion legislation, which ensures certainty and predictability, and stopping this whole thing where you've got to be concerned about litigation 2 years, 5 years, or 50 years later over something that you did that was permitted and was using the best science at the time. You are chilling investment by providing uncertainty and taking away one of the best benefits of the United States of having a rule of law, having certainty and predictability in your investment.
On the climate liability lawsuits, I find myself counting on the appellate courts and the Supreme Court to sort of shut these down. Breakthrough Institute actually just my organization just filed an amicus brief in the latest suit brought by Our Children's Trust against the Trump administration on similar grounds. And so I'm hopeful there that this sort of style of extrajudicial climate policy pursuit will ultimately be sort of snuffed out by the courts. On permitting, I can't agree enough with Congressman Graves, and I agree also with the specifics that Paul laid out a few moments ago on what is really kind of known and is and in many ways a sort of bipartisan consensus for how to fix NEPA. The only thing that I would add is that we shouldn't just we shouldn't just advance the SPEED Act this Congress and pass permitting reform this Congress. We should be passing 5 big permitting reform bills every session of Congress for the next decade. It's not just NEPA. It's the Endangered Species Act. It's the Clean Water Act. It's parts of the Clean Air Act. It's the National Historic Preservation Act. It's the Jones Act. And that's just at the federal level. I talked in my opening remarks about the emergence of a public interest in environmental movement 50 years ago. We need a whole new kind of advocacy agenda and sort of legislative agenda for how to actually do good sort of environmental protection, but also sort of good infrastructure policy in the United States for the 21st century.
Just briefly on the courts solving this, I think at some point for the climate lawfare, the Supreme Court is going to have to step in and solve it. They can either do it now when it's still in the relatively early stages and essentially it's all just a litigation tax, or they can wait for there to actually be a final judgment against one of these companies for hundreds of billions of dollars that will force it into bankruptcy. And the Supreme Court will then have to step in and unring that economic catastrophe bell. And so they're going to have to fix it, and hopefully they do it soon.
Paul?
I think there's universal alignment that the time is now to address our permitting challenges, and I think that this is a unique opportunity, and I think it would be an absolutely fabulous achievement going into the midterms for our members of Congress to be able to go out and say that they truly delivered for the American people this year. So I hope springs eternal. For any more information on API's permitting priorities, folks can go visit permittingreformnow.org, where we have our roadmap for permitting reform available for everyone.
So this concludes our discussion today. I would like to thank all of you for your generosity with your time. The recording of the event will be available on our website. Thank you.